Hi, everyone. Thanks for joining us today at the criminal law section of the Beverly Hills Bar Association for our panel discussion on recent and upcoming Supreme Court cases involving criminal law. My name is Michael Freedman. I'm the vice chair of the criminal law section, along with David Kerman of O'Melveny, who is the chair of the section, and Remy Salter of Steptoe and Johnson, who is the program chair. We've got three great speakers today who I know you're all going to learn a lot from. I've already learned a lot just from our prep. We've got a lot to cover, so I'm going to introduce them and go over a little bit of housekeeping. We probably will not have time for questions. We've got a jam-packed program, but if there are burning questions, there's a way to put them up on Zoom, and I will try to get to them if we have any time left over. There are some program materials that the Bar Association will circulate. There's a link right now that you should see in your screen, and I think they'll send out an email in the next day or two as well. So without further ado, let me introduce our fantastic speakers. First up is Alyssa Bell, who's a partner at Cohen Williams in Los Angeles. She's a seasoned criminal defense attorney and appellate specialist. She spent 6 years at the Office of the Federal Public Defender in LA, including in the appellate unit and as impact litigation coordinator. Alyssa began her career as a law clerk on the Ninth Circuit to Judge Richard Paez and in the Central District to Judge Margaret Morrow. Next up is Laurie Levenson, who is professor of law and David W. Burcham Chair in Ethical Advocacy at Loyola Law School here in Los Angeles. Laurie's a leading expert on criminal law and procedure and ethical lawyering, just to name a few topics, and has been. She started her career as an assistant U.S. attorney in Los Angeles, where over 8 years she served in the appellate section as well as a supervisor. And before that, as a law clerk to Judge James Hunter III on the Court of Appeals for the Third Circuit. And then our final speaker today is Kendall Turner. Kendall is counsel at O'Melveny in Washington, D.C. She focuses her practice on appellate matters in federal and state court. Kendall argued before the Supreme Court in 2019 in a criminal case and won a unanimous reversal of her client's sentence. That was not her first experience before the Supreme Court. She served as a law clerk to Justice Stephen Breyer, and before that to Judge Merrick Garland, now the Attorney General, when he was the Chief Judge of the DC Circuit. So what we're going to try to do today with these fantastic speakers is talk about some of the highlights from last year and this coming year, and also take a look at some of the broader themes that the panelists are going to illustrate in terms of what the court's doing on a case-by-case approach, and in some instances chipping away at stare decisis, what trends we're seeing with the three new justices, in particular, more of a textual focus, and unfortunately, in some circumstances, less practical experience in the trial courts. And we're going to talk about how some of that's already playing out in lower courts in criminal cases. We're going to take the cases in rough subject area, starting with some Fourth Amendment cases, and then sentencing, and then habeas corpus. And then we're also going to touch on one of the bigger cases from last term, and then probably the biggest case this coming term. So let's kick it off with the Fourth Amendment. I'm going to just summarize these three cases very quickly, and then I'll start with Laurie. So there's three cases we're going to discuss: Torres versus Madrid, Caniglia v. Strom, and Lang v. California. In a very brief nutshell, Torres versus Madrid, all of these cases, I should say, were in favor of the defendant, although in a somewhat narrow fashion. So Torres said that the application of physical force to the body of a person with intent to restrain is a seizure, even if the person doesn't submit. Caniglia says there's no open-ended community caretaking exception to the warrant requirement, and an exigency must be shown. And then Lang is a hot pursuit case of a suspected misdemeanor offender, and says that that kind of a pursuit does not categorically allow warrantless home entry without a law enforcement emergency. So Laurie, I want to start with you and ask you for your interpretation of what the court's doing with these kinds of rules, or whether you would call them rules in cases like these.
Absolutely. But let me first thank you, Michael, and my co-panelists who are just amazing. And I see on the participants several former and current students and lots of friends. So thank you, everybody, for being here. Let me address what I think the Supreme Court has been doing in the Fourth Amendment area. I think that they're examining some of these exceptions to the warrant rule and some other issues that have been coming up, and coming up with decisions that people might think are surprising, but not as surprising as the overall decision really is. Let's take mention of Torres that you said. So the issue in Torres was really in the civil context of when there's excessive force for a seizure. And in that case, you had a defendant who didn't realize that they were trying to serve a warrant on her, or at least that's what she said. And the police went after her and started shooting. And they didn't actually stop her, even though she was hit twice by bullets from the police. And in that situation, the question is, when did the seizure take place? Under a prior decision called Hodari, the Supreme Court Scalia had said, you're not really seized until you're stopped. But in this decision, in a narrow decision, the Supreme Court said, well, if you get hit with a bullet, we're going to call that enough of a seizure, at least for the civil case. For those of you who are out there practicing in the criminal arena, I'm not sure that this case has that much impact, because there's also language that says until you stop for a criminal case, it's an ongoing pursuit. So if she were discarding evidence before she actually stopped, she didn't stop for another 75 miles as she drove off and eventually got to the hospital and was arrested, I'm not sure that this really makes much of a difference. In the other case, the community caretaking exception that in Caniglia that the court raised, you know, the Supreme Court had to deal with the issue of whether there's this other broad exception to the search rule. And the state had been promoting that, you know, when the officers showed up to get the weapons that Caniglia had, because his wife was afraid of the fact that he might use them against himself or against another, that you shouldn't use this new exception called community caretaking. You should go back to the solid ones we already have, which are exigent circumstances. But I do think that the court would still be open to community caretaking or exigent circumstances going in without a warrant when the police are truly concerned about the safety of others. You know, everything good in life is in footnotes. There are a couple of footnotes in that decision, Michael, about 32,000 older adults die from falls every day, that over 47,000 people 2 years ago committed suicide. And so there's lots of language in the concurrences that says, we don't want you to have a broad exception, but if you had a scenario where an elderly person is expected at your house and doesn't show up, and you're really worried about their welfare, we might see that as differently. Overall, there is safety in using the old language of exigent circumstances and not adopting some of this new language of community caretaking.
Thanks for that. I think that's a very interesting point you raised at the end, in particular about these specific examples that the court's getting into around the edges. So I want to ask Kendall for her thoughts on what do you think are some of these other factors that the court's going to have to consider in these kinds of cases in the future in light of the not fully clear rulings that we have to date?
Well, I think it'll be interesting to see, you know, in Lang in particular, the court said this is really a case-by-case analysis. You can't set out these clear rules. And I think it'll be interesting to see whether that is really how it plays out. You know, there are some factors that could affect, for example, whether someone might feel free to leave, or whether something might be, in effect, a Fourth Amendment seizure, such as someone's, you know, gender or age or race or disability status, that courts have been reticent to consider in the Fourth Amendment analysis. Some courts have been reticent to consider because they think it raises a equal protection problem. And you see that sort of same type of equal protection concern arising in some other criminal contexts too. For example, you know, in the follow-on to the Miller litigation about whether you can consider someone's life expectancy in evaluating whether a sentence is a de facto life sentence. And some courts have said that if you consider those factors that are specific to someone's, racial background, that can raise an equal protection problem, and other courts have found no difficulty in doing that. So I think it will be interesting to see how case by case these rules really are applied, and if factors like that are considered going forward.
Great, thanks. Alyssa, what do you think that these cases do in terms of opening the door to these kinds of considerations? And what have you seen in your practice?
I would say from a practitioner's perspective, the Lang decision felt motivated to me by our particular cultural context. I didn't see Lang coming out the way that it did without the murder of George Floyd and without, the real reckoning that America has at least begun to do when it comes to racial justice. And, there is no exclusionary rule for a racially motivated stop. So it's been difficult to bring race into the courtroom. There's no real lens to do so, but we must. This is so often our client's story about how they got to be in the position where they were. I hear, so frequently still in my practice, because although now in private practice, I still am on a member of the CJA panel for a few different districts. And so I find that people tell me, this police officer knew me, he's been plaguing me. He's been following me because of a prior arrest. I certainly understand sort of the long arm that the law has over communities of color. I've seen it firsthand so often, but I think it's been difficult for me, and I'm sure for many of my colleagues, to find a way to make that legally relevant. And I think we have to tell that story over and over again in our suppression motions. And it's only through doing that we're going to be able to create, hopefully, a window of light for that to become a legally relevant consideration in the future.
Michael, I'd like to pop back in because I didn't talk about Lang and respond to some of Kendall and Alyssa's remarks. So, Lang was a case where the state had originally argued for a per se rule that in a hot pursuit, even if a misdemeanor, this guy's really obnoxious, like he's driving, playing his music loudly, honking. And then they stop him within 4 seconds of his garage and run after him. And the court easily says, we're going to take it on a case-by-case basis. We're not going to have this broad hot pursuit for misdemeanors. But I'm still not hearing the court say that they can consider the subjective intent of officers. And that's where the line is really drawn. In fact, I think that the current concurrences are all over themselves to say, we think it'll ordinarily be exigent circumstances. We would think that, chasing after somebody, even on a misdemeanor, we're worried about them destroying evidence or getting away or hurting someone. I didn't hear any of the justices saying, we really know what the officers are trying to do here. And that's going to be a challenge to get that in front of any judge at this point.
Thanks for that, everyone. Let me turn us now to Van Buren versus United States, which was probably the biggest criminal case of the last term. And Kendall, if I could ask you to tell us a little bit about the case and what you think it reflects about some of the trends that we're seeing with the court these days.
Sure. So I'll just say first, before this case was decided, it may have been a crime for you to share your Netflix password, but now you can all rest easy. So the case was about the Computer Fraud and Abuse Act, which if you have never heard of, you can be forgiven. But under that law, a person engages in criminal activity if he accesses a computer without authorization or exceeds his authorized access and thereby obtains information from the computer. And the law defines exceeds authorized access as meaning to access a computer with authorization and to use such access to obtain or alter information in the computer that the accessor is not entitled so to obtain or alter. And the reason I'm quoting that is because the decision in the case was very focused on the text of the statute, and in particular on the word so. But the majority and the dissent had very different views of what the word so meant. I think this case is interesting both as an illustration of how textualist the court has become, but also how text doesn't get you all the way there, or that there are often different views about what even a very small word like so can mean. And so the opinion, the majority was a Justice Barrett opinion, was one of her, maybe her third, I think, in her term. So it's interesting to read just in terms of figuring out what her style is. And the dissent was written by Justice Thomas. The upshot is that as a result, as I said, sharing your Netflix password, not a crime. Also, if you access Amazon on your work computer during work hours, there was some concern that that might be a crime if you read the text of the statute the way the government had asked the court to construe it. But that is not how the court interpreted the statute. I will also say, just as a teaching example, this opinion is really useful because the majority goes through text, and then it goes through structure, precedent, history, and then a sort of like rule of lenity argument that they don't call it a rule of lenity argument. So if you are teaching anyone about statutory interpretation, I really encourage you to use this as an example.
So Alyssa, a little closer to home in the Ninth Circuit, this Netflix password question has been a long running issue, but the Ninth Circuit's changing a bit as well with new judges. And I'm curious if this sort of textualist approach that Kendall highlighted has started to percolate down.
Yeah, that it has, very much so. I don't know so much as percolate as hit us over the head, because I mean, I would say that the Trump administration's effect on the Ninth Circuit has really been profound and outsized. He filled 10 vacancies, and that really changed the composition of a court that was known for being one of the most reversed, one of the most liberal, to quite the opposite of that. I think if I'm not mistaken, the count is of the, we have 16 active judges that are liberal, 13 that are conservative, but then there are the senior judges, and 3 of those are liberal and 10 are conservative. So your chance of drawing a conservative panel, all 3, 2 out of 3, is very high. And this has a huge impact also on en banc activity, because, I wonder whether some of the more liberal judges are going to be less inclined to call a case that seems problematic en banc, because luck of the draw, you could end up with a very conservative panel and a decision that goes even further in a different direction and has, is more impactful because it is an en banc decision. I had sort of a sad anecdotal experience of this somewhat recently when I was representing a client on a compassionate release petition, and that was denied. And I contacted my local public defender's office. This was in a different district, just to coordinate and touch base. And they said, please take another stab at the district court, find some changed circumstances and file a new petition unless your client is dead set on appealing, because we need some other circuits to weigh in on this particular open legal question. We don't want the Ninth to be first. And that really just punched me in the gut, because I would say grew up in the Reinhart-Pregerson era. And it really is a very different place to practice. So, for me in practice, and I would say for all of us practicing both at the district and the Ninth Circuit level, we need to be very aware of the textualist approach that, it's not only the Supreme Court, it really is the Ninth Circuit that's going to be using that approach as well. So the place to start, almost for the first time in my practice, at least, is with the statute. And how does this compare to the case law? Is there a disconnect there? And that disconnect is what we need to be exploiting, even in the very early stages of litigation.
Interesting. Thank you for that. So let's turn to some sentencing and other long running issues at the court. And we're going to start with the felon in possession statute. And there were 2 cases decided on the same day in this area, Gary and Greer. And Kendall, if I have it right, you worked on some of the briefing in Gary. So if you could tell us a little bit about what these 2 cases are about.
Sure. So in 2019, the Supreme Court decided a case called Rehaf, which held that in a federal prosecution for illegal possession of a firearm, the government was required to prove that the defendant knew of his status, his felon status, and that he was barred from possessing a firearm. At the time that Rehaf issued, Mr. Gary, who's our client, had already pleaded guilty without being instructed that the government had to prove that element. He raised the issue in a Rule 28J letter on appeal, and ultimately this is before the Fourth Circuit, ultimately they vacated his convictions and remanded to the district court. It assumed that the claim was reviewable only for plain error, but concluded that the Rehaf error was structural. At the time, and subsequently, the Fourth Circuit was the only one to take that view of a Rehaf error. So the Solicitor General sought the Supreme Court's review, and they got it. And the court decided, as he said, decided Gary in the same opinion as Greer. The difference being that Gary was a plea case and Greer was a trial case. The court held in an opinion by Justice Kavanaugh that a Rehaf error is not a basis for plain error relief unless the defendant first makes a sufficient representation on appeal that he would have presented evidence at trial that he did not know he was a felon. I think the part of the frustrating thing for me about this opinion, aside from the fact that it was decided together with one other case, even though I think there are different implications in the plea and the trial context, is, one of our arguments was, if all courts of appeals have decided an issue against you, so there is uniform circuit precedent, it's just not reasonable to expect defense counsel to raise every objection to controlling precedent. Sorry, that's my landline. Haven't gotten a call there in a while. And people will have to be retrained. Trials will be much longer than they used to be. You'll have to sort of take a new view of ineffective assistance of counsel. But I think that argument really didn't land because, as Michael mentioned at the beginning, there aren't a lot of people on the court who have trial experience in criminal cases in particular. And so I think just trying to explain how much those objections would gum up the works just didn't really come through. And I think also there was this sort of sense of, well, you must know if you're a felon. But it's actually it's not always clear to people, particularly in certain jurisdictions for certain offenses. It's just not, people don't always know that they're felons, and therefore forcing the government to prove this element is actually materially different. But I think that was also hard to communicate for the same reason that justices generally do not have experience in criminal matters.
So Alyssa, if the last case is sending you to the statutes, are these cases gumming up the works now down below, as Kendall put it?
I would say Gary is sort of an unmitigated disaster in the court's refusal to recognize a futility exception to the preservation requirement, because it has a host of implications. For one, as a practitioner, you need to be aware at the very earliest stages of litigation, whether it's in plea negotiations or whether it's in the pretrial motions context, of exactly what issues that have been uniformly decided against you and everyone for decades, perhaps, may be ripe for this court to revisit. Because as I'm sure we'll talk about coming up, this court does not seem particularly married to the idea of binding prior precedent. So you must be aware of what those issues are, and then you must preserve them. And preserving them can be incredibly time-consuming and awkward, as Kendall was saying. Are you going to put the jury to sleep? Are you going to distract a sentencing judge from what your really great issues are with all of these other issues that you have to preserve? So maybe in your brief, as Laurie said, you can make good use of footnotes, but what are you going to do when you're in front of the jury? So it's really a very problematic requirement. I did also want to touch just for a moment on Greer, because I think, on the flip side, that creates a certain opportunity for appellate practitioners. And that's because the court said, because the burden is on the defense on plain error review to show that the defendant's substantial rights were affected, the defendant can do so with evidence outside the record. And there, I think what the court had in mind was looking at the PSR. So, pointing to something at the PSR to say, there's this showing that could have been made. But the language is broader than that. So there is an opportunity to present new evidence on appeal. And, if you are an appellate practitioner, this is really shocking and there's a real sea change, or I'm sure it won't ultimately be interpreted that way, but at least there is an opportunity there. And I did this recently in this very bizarre case where essentially the district court answered a juror note without holding proceedings on the record. The district judge came out into the hallway and had a brief conversation with defense counsel, informed defense counsel of how he would respond to the note, and then sent the note back to the jury. And when the record again opened and there was an opportunity to lodge an objection to that, he said, "I don't recall it that way. I recall that we had a hearing and you were all here," even though that hearing was off the record. So the Ninth Circuit is sitting with a factual dispute between the district court and defense counsel, and an oral argument tried to say, how don't we defer to the district court's factual findings? Didn't defense counsel not make a great record on this? So citing Greer, we filed a 28J along with a motion to supplement the record with additional declarations of the other members of the defense team who were present. That hasn't been ruled on yet, but it was an interesting wrinkle to be able to throw in there, and one that I suspect, even if they ultimately don't decide in our favor, may shift the balance in their thinking. At least I hope.
Hopefully. Laurie, what do you think about this issue that we've been discussing, the lack of trial experience with the court and the new justices in particular?
Right. I think Kendall and Alyssa, of course, hit it on the head, which is it does matter who's on the Supreme Court. And it doesn't just matter how smart they are, what their credentials are, but experience is very, very important, especially in some of the areas that they're ruling on. And you get the sense that they do not have the instincts for what's happening in trials or even pleas, or what it's like to deal with a client, what it's like to appear before the jury, to make your record, and what it's like even to take on a judge who you think is misrecollecting what occurred there. In that regard, I see even in this and other areas that Justice Sotomayor's voice is terribly important, because she does have that sensitivity, both what it's like to be out on the streets, going back to the Fourth Amendment cases and being stopped, and what that humiliation is like, and why the court really should care about those and not just approach that in, quote, an intellectual manner, but also in these areas about making the record. There is a certain dynamic of what happens in a case, and how do you, after the fact, say to the court, no, we really would have handled this differently in representing our client had we known that this was a requirement, which is exactly why you should see it as a structural error, because going back and trying to put it back together is really not as easy as the court thinks.
Alyssa, I think you touched briefly on a compassionate release case that was involving the First Step Act. So I want to ask you to take the lead on talking about Terry versus United States, which was a sentencing reduction case under the First Step Act, and tell us a little bit about that and how the court's been handling the First Step Act so far.
Sure. So Terry is a case in where the court held that sentencing reductions under the First Step Act are available only if the offender's prior crack cocaine offense triggered a mandatory minimum sentence. So just a bit of background, we previously had this terribly draconian distinction between crack and cocaine offenses. There was a certain quantity of crack cocaine that triggered a series of mandatory minimums. An unspecified amount of crack cocaine didn't trigger a mandatory minimum sentence at all. And of course, it sort of goes without saying at this point that this had the most outsized impact on people of color who were at that much more likely to have possessed or dealt in crack than in cocaine. So for Mr. Terry, this is sort of an unsurprising result doctrinally, but a very disappointing result in terms of the practicalities of it. And that's because he pled guilty to having had an unspecified amount of crack cocaine. There was no mandatory minimum triggered, and the court ultimately, that's what's outcome determinative. because it didn't, result in a mandatory minimum sentence. There's no relief available to him under the First Step Act, which sought to ameliorate these historical disparities. The problem is that same fact of his cocaine possession is what triggered his guideline sentence. And his guideline sentence was that much higher because he had possessed crack as opposed to cocaine. And also he had prior offenses that ultimately triggered a career offender guideline sentence, which is really through the roof. So in the real world, I think, all the justices knew that what's really driving this here is that this human being was involved in this, what really was a particular historical moment of how we were treating this kind of offense so very differently than other offenses, which really aren't as a moral, on a moral basis any more culpable. And Justice Sotomayor is the one who talks about this in her dissent, but otherwise, no other justice was willing to engage in the reality of this. And it's a really, unsurprisingly textually driven analysis.
Kendall, what's your prediction in terms of how the court is going to deal with these first step issues that are going to be developing in the years to come? Do you think that's going to be an active issue?
I do. I think it already is very active. There have been many petitions filed over the summer raising different splits having to do with the First Step Act. There's Bryant from the 11th Circuit, which talks about whether a particular policy statement from the sentencing, a particular policy statement that requires that disempowers the defendant to file a petition for compassionate release, it still applies now. And there's a different one about whether sentencing courts have to consider all of the relevant federal sentencing factors in considering a compassionate release petition. So, I think sort of in the ACCA context, the court, I think, is very tired of those cases, but has to keep taking them because there are continually splits. I think in the First Step Act, we'll see a similar thing, at least over the next few years, because there are already a number of splits about how to apply this statute. I'd also say, going back to a point, I think, Michael, you raised earlier about all the good stuff is in footnotes. Borden, which Alyssa was talking about, is just, it's like very intense writing, and there are some very heated footnotes in case you are curious to read it.
So it was, I think Laurie gets the credit for the footnote point. But I'm glad you mentioned the ACCA point, because I want to ask you about another case from last term, Borden versus United States. And you mentioned ACCA, which is the Armed Career Criminal Act. And that's been a long running issue at the Supreme Court that I think you're right, they're pretty annoyed with. But tell us a little bit about what that long running issue's been and why they're annoyed with it in your view, especially in Borden. Kendall, that's for you.
Oh, sorry. So ACCA has changed over the years because part of it was held unconstitutional. But essentially it's provides for certain sentencing enhancements where someone has certain predicate offenses that are violent. But then you have to figure out what are violent offenses. And it turns out that's quite complicated. And, you have, I think, probably people on the prosecution side spending lots and lots of time analyzing like second-degree burglary in Delaware. And I think it makes everyone want to tear their hair out a little bit. So that's why I say that they are annoyed about ACCA in general. And then I think, I don't know if anyone said exactly what the holding of Borden is yet, but it was a case that resolved a long-standing disagreement in the courts and held that reckless prior offenses, in other words, offenses committed with that mens rea, do not qualify as violent offenses that qualify as predicate offenses under ACCA.
Thanks for summarizing that. Laurie, do you see a theme between these two different lines of cases, First Step Act and ACCA, in terms of what the court's so annoyed with?
Yeah, I do, but let me settle this dispute. Everything good in life is in footnotes is actually in Legally Blonde. So let that be known to people. Yeah, here's a theme. First of all, I want to say I think the Terry case was a terribly sad and disturbing case. I mean, here's a fellow who had, I think the record showed about 3.9 grams of crack cocaine. He did have prior convictions, but it was when he was a teenager. And so you had in that case actually amicus briefs being filed by former federal judges saying he would never get a sentence like this now. But all of that gets lost because an overriding theme here is that Congress tends to write convoluted and pretty lousy statutes to deal with important issues that actually affect people's lives. So the Supreme Court comes in and narrowly sort of reviews these statutes. It's in the weeds, to be sure, as Kendall and Alyssa pointed out. And some defendants win, but most of them are going to lose because we don't have particularly clear statutes that govern the most important part of a case. Let's not forget that most defendants are not going to trial. Everything is about sentencing. And then you get into these statutes, and after the fact, you realize that there probably has been a grand injustice. Not because it was intentional, but because these statutes have not anticipated how they're going to affect various cases. That's true with ACCA, that's true with the First Step Act, and it's just going to keep continuing because the statutes are on the books, and until we see how they affect individual cases, we won't see what the impact is of how these statutes are worded. And again, you have to have enormous patience, like my colleagues here have, to even read through the statutes to get the language before the court again.
Yeah, if I could just jump in here for a second too, the problem with interpreting the ACCA has really had a tremendous impact on practical impact on federal defender offices around the country. And that's because, when the Supreme Court decided finally that it's this third clause of the ACCA, which was called the residual clause, which basically was this very vague and ultimately void for vagueness way of saying like anything else that involved violence. And it had this practical approach called the ordinary case approach, where one had to figure out what the ordinary case of a prior predicate was, like what is the ordinary reckless driving? What does that involve? What conduct does that involve? And does this ordinary case involve force or violence? And finally, the court, after spending years trying to interpret that, threw it out the window in 2015. And that left these other two clauses in the statute. So whereas before, all of these people were getting ACCA sentences under the residual clause, now the question was, can those still stand under the two clauses that remain standing? And it wasn't just ACCA. There's a similar structure in the career offender guideline context. So ultimately, it became this monumental undertaking for defender offices around the country to identify who are all of the people who could potentially be eligible for relief, and how can we meet our 1-year deadline to file on their behalf. And many of them have such long sentences, they've been litigating themselves for a long time. So first step is to go to the circuit court and ask for permission to file a second or successive. And then, beyond that, essentially you have hundreds of clients who have largely redundant legal issues, but, little wrinkles in their case. And how do you do a good job of making sure that you have, the legal issues really well briefed and well preserved, but someone has taken the time to look at very specific factual circumstance to see if there's something that makes them different, either in a good way or a bad way. I had the perhaps dubious distinction of being one of the Johnson coordinators at the Federal Defender's Office for the better part of a year. And I have to say it's some of the most challenging and also mind-numbing work I've done at the same time, because every time a new legal issue came up, every time the government came up with a new way to throw up a roadblock, it took all of the best minds in the defender community to come together and figure this out and come up with what our standard response would be. And then you had to replicate that over hundreds of cases in the appropriate way. And it was terrifying, the one time that you feel like someone fell through the cracks, that you forgot to file this supplemental brief in their behalf. It was very stressful. So these little wrinkles that the Supreme Court keeps throwing out there are really wreaking havoc, I would say, kind of across the board.
I was a young AUSA on the other side. I can assure you it was equally mind-numbing. That's a bad point on which to transition into our next topic, which maybe is the most exciting of the panel. I want to talk about some of the habeas corpus cases. And Laurie, if I could ask you to tell us about Jones versus Mississippi.
Yeah, I'd be happy to do that. And I know when you say the word habeas, people's eyes start to roll back, but they shouldn't, because these habeas cases are so heart and soul of what the criminal justice system's about. And that's particularly true, Michael, of Jones versus Mississippi. It was a 6-3 decision written by Kavanaugh, and many people will remember the background of this case. In this case, the Supreme Court back in 2012 decided the Miller case. And they said that you could not have a mandatory life without the possibility of parole sentence for juveniles. And then they decided in Montgomery that decision was substantive and therefore should be retroactive. So what that meant is that for those people who had gotten LWOP sentences, they should be able to go back to the trial court and argue why they're not incorrigible and why not maybe that day, but at some point they should be eligible for parole. So Jones did just that in Mississippi. And he went back and there was a hearing. He had stabbed his grandfather. It was a terrible crime, but he was 15 years old. And, he didn't try to call 911, and he did try in a sort of a sloppy way to hide the body. And he was convicted and got an LWOP sentence. When he went back on post-conviction relief to try to persuade the court that, in fact, he was not the same person. He was 31 years old by this time, and that he should be eligible for parole at some point in his life. The judge heard the evidence and then summarily said, "You lose," and never found specifically that he was incorrigible, never put on the record why he was incorrigible. And in fact, Jones had presented quite a bit of evidence that showed he was a changed person. He had, as Sotomayor presented in her dissent, the grandmother testified that she thought he wasn't incorrigible, that many of the attributes of this crime were because of his youth, that the fight that he got into with his grandfather was over a girl, and what his grandfather had said about the young lady, that he had provided evidence of rehabilitation, that in fact he was somebody who had seen what he had done as a youth and is trying to change. And most importantly, look at his background. He himself had been a child who had been subject to a lot of violence and abuse. He had mental health issues. And those are the types of things that, in fact, might influence these types of crimes. So when Kavanaugh says, it's good enough just for a judge to hear it and then make a finding, you lose, that's not respecting what the court was trying to do in Miller and Montgomery at all, because he's now facing life without the possibility of parole, and there's no real record for a higher court to evaluate whether, in fact, he should be subject to that. I thought there were some interesting things in here. Depending on where you have the luck or bad luck to be, in Pennsylvania, for example, only 2% of the youth who got the LWOP sentence are subject again to the LWOP sentence. In Mississippi, it's quite different. And going back to a point that Alyssa and Kendall have been making, 70% of the juveniles who got these LWOP sentences were defendants of color. And that cannot be ignored. So I think this is a case where the court has very rapidly undone the good of Miller and Montgomery by procedurally saying the judge can just make a blanket finding.
Thank you. So our next, I want to stick with you, Laurie, and ask you about Edwards versus Fenoy, which illustrates your point about the heart and soul of criminal law in these habeas cases, because this is a very important case about habeas review and the watershed rule exception to non-retroactivity, and it's another Kavanaugh opinion. So tell us what's going on there again.
And this goes beyond what Justice Kavanaugh had to do. So this is an issue in Edwards versus Fenoy about Ramos. As the viewers might remember, the Supreme Court reached the decision in 2020 that jury verdicts have to be unanimous. You might think that's kind of a watershed, really important procedural rule. And the issue that went up in Edwards versus Fenoy is whether indeed that would be retroactive. Because under Teague, if it is a watershed, a big deal procedural decision, it would be retroactive. Now, the Supreme Court and Kavanaugh decide it's not a watershed rule. All right, but he went further than that, Michael. He said, we never are going to find a watershed rule. So we're just not even going to have that part of the rule anymore. We haven't found it yet in cases like Batson and Duncan and Ring. And since it's kind of in disuse and we don't want to hold out, I guess, false hope, we're striking even the possibility that a rule would be retroactive under the watershed exception. I find this to be extraordinary because it really does, I think, ignore stare decisis. It's a court coming in and saying, we never liked the watershed rule. Thomas in himself says we never should have had it. And this was, one that we shouldn't have adopted. And not just affecting this decision for this habeas petitioner, but really putting up a roadblock for petitioners coming down the pike.
Thank you. So we've got just over 10 minutes left. So I think it's a good time to turn to some of the upcoming cases. We're not going to go into as much detail on as many of them, but Kendall, since we talked about ACCA a few minutes ago last term, I know there's at least one, maybe two other cases coming up. And one of them, I think you were involved in briefing, United States versus Taylor. So if you could briefly summarize for us what that case is about and compare or contrast it to the issues you were discussing from last term in this area.
Sure. So Taylor is a case about whether attempted Hobbs Act robbery qualifies as a crime of violence. And you might, I think some people, many courts in particular, have this sort of intuition that, of course, Hobbs Act robbery and attempted Hobbs Act robbery is a crime of violence. But if you look at the text, you can actually commit attempted Hobbs Act robbery through an attempted threat. So that could be, for example, maybe you get in the car and you're going to drive to the bank or something, and you have a note in your pocket intending to threaten the teller, but you never actually do it. Or even if you just think about doing that while you're driving towards a bank, that could be an attempted threat under the Hobbs Act, or that could be a form of attempted Hobbs Act robbery. So the question is whether attempted Hobbs Act robbery categorically qualifies as a crime of violence under ACCA. I think that the text, this I think will be a very heavy statutory interpretation case. The text, I think, is going to be the most difficult thing for the government to wrestle with. It's sort of, at least at the search stage, pointed to sort of like, it's kind of like the old ordinary case analysis that Alyssa was talking about, saying, in most cases, attempted Hobbs Act robbery involves violence. But that's not how we assess anymore whether something qualifies as a predicate offense under ACCA. So there's sort of some ACCA cases, the text is with the government, some ACCA cases with the defendant. And I think this, I'm biased, but I think the text is better for the defendant here, will be more difficult for the government to wrestle with.
So probably the biggest upcoming criminal case, which may not have a huge impact doctrinally, but just in terms of headline value, is United States versus Tsarnaev, which is the Boston Marathon bomber case. Laurie, tell us a little bit about the issues that this case raises and what you see in terms of their impact, if any, more broadly.
Yeah, this is a high-profile case going to the Supreme Court because it involves the Boston Marathon bombing. And even though I think it was Eric Holder who originally authorized seeking the death penalty, we now have the Biden administration that has generally said they don't want the death penalty, but they're pursuing this appeal before the Supreme Court. In this case, Tsarnaev, as you recall, Zohar Tsarnaev, he was the captured younger brother. I think he was 19 years old. His older brother was killed in a shootout before he was captured. And Tsarnaev was convicted. He had written in blood on a boat, sort of that this was part of his jihad. And not even the great Judy Clark, who's an amazing appellate lawyer and trial lawyer for the death penalty, was able to save him from that jury verdict. But on appeal, he raised a couple of issues. In fact, he kept raising throughout the case questions about pretrial publicity, voir dire, and venue. And he got shot down during the case. But I expect that issue is going back up to the Supreme Court to really look closely at what kind of voir dire do you get in a case? Is it enough to ask jurors about, have you heard a lot about this case, but really probe more how it affects them? Because given where the venue was in this case, and given that there were tanks on the streets of Boston, it might have affected. But there's another issue, Michael, in this case, and it's a Brady issue. Because it turns out what the government had turned over was information about the older brother who had committed several horrendous homicides. And when it gets to the mitigation phase in a death penalty case, Zohar should have been able to argue, look, the really bad guy here is the guy who's not on trial because he's dead. But don't take out your vengeance on me. And he didn't have that information because the government hadn't turned over all the details of his older brother's activities. So that's the Tsarnaev, the case that's going before the Supreme Court. And it's going to be argued actually very early in October, on October 13th.
Thanks. Kendall, Laurie made a point about the Holder DOJ, and then we've been through the Trump era, and now we're in the era of your former boss, Attorney General Garland. And I'm curious, you're in DC, you're dealing with probably the Solicitor General's office on some of the appeals you're working on. I'm curious if you have any thoughts or comments on any changes we've seen with the Biden DOJ at the Supreme Court and the Solicitor General's office recently, or is it too soon to tell?
Are we just talking about the criminal context?
Yeah, criminal.
Because Judge Garland has been in the news quite a bit lately in other areas.
There's an upcoming panel, that'll be our plug for the Bar Association.
Yeah, that's right.
General Supreme Court panel with Erwin Chemerinsky on this Friday, but we're gonna stick to criminal for now.
So, I think it's not just true between the last administration and this administration. I think anytime the political party in control flips, you see that culture is actually quite sticky at DOJ and the SG's office. In maybe like 85% to 90% of cases, their positions are not really changing. It's not to say that there is no difference. There certainly is. But I think the case that Laurie was just talking about, even though in some ways it's sui generis for a death penalty case, is an example of a way that some people might have expected a position to flip, but it has not in fact flipped. And I think that that's true in many cases in which the SG is involved.
So Laurie, you talked a little bit about Kavanaugh in those two opinions you discussed, but let's take the last few minutes to sort of look a little more broadly at the trends on the court now that you've got three new justices, and not only those three new justices, but how do you see the composition and the trend lines changing with the justices of the court in the coming term and beyond?
Well, as you started out by pointing, and I didn't go into all the details on the Fourth Amendment cases, the court seems to want the parties to stick to traditional doctrines, and those doctrines also on a case-by-case basis. Maybe that allows the court to come together with a new constituency and figure out what direction they're going, but that has been at least in the Fourth Amendment area. Beyond that, however, my major concern is that some of the youngest justices have come in and their minds are made up. And you can tell their minds are made up because they're willing to sort of throw out stare decisis. So in the Fenoy case, that all the cases, I think is the one that is most telling about the dramatic changes we will see because we have the new justices on the Supreme Court. And the traditionalists, I think, don't have the votes necessarily to take that on.
Thanks. Alyssa, let's wrap up with you in the few final minutes. And I know it's a lot to throw at you in a few minutes, but your thoughts on those issues, both in terms of stare decisis at the court generally, and then you talked a little bit earlier about some of the changes on the Ninth Circuit textually, but I'm curious what other changes you're seeing there, sort of along the lines that Laurie's illustrated on the Supreme Court.
Yeah, I mean, I guess we are just going to have to take some lemons and make lemonade. Is all I say about how we're going to have to navigate the situation, because, you know, the practical impact of draconian laws on our clients is no longer going to be a motivating concern going forward. I think what we need to do is figure out how to use text to our advantage wherever possible, because that's the argument that's going to win the day. So ultimately, that's, you know, what we're penned into. I think that we should try, if we can, to take advantage of this court's willingness to limit the precedential effect of prior decisions, if not to, you know, obliterate it outright. For many of us, that's very troubling and disheartening, because there are longstanding laws that we care very deeply about. But in the criminal law context, there are laws that have had terrible consequences for our clients, and we can look to challenge those if we can find a textualist way to do so. And an originalist way, I should say. We should all really be more familiar with our American history and with our common law history, and figure out whether there was a way in which something was punished at common law, which would be more consistent with the statutory text, as opposed to what we see in practice today.
Great. I think that's a very good and interesting practical point to end on. Let me thank each of our speakers today. I certainly found this to be very informative and educational, and I appreciate the work you all put in, and I appreciate the members of the audience joining us today, and hopefully they found it to be equally enjoyable. And thank you, as always, to the Bar Association for putting this all together. And I think we're going to call it a day there, and we'll all go forward into October and watch what the Supreme Court does in 2021 and 2022. So thanks, everyone, and take care.
Thank you.
Thank you so much.